In this video, I'm going to give you clear and concise answers to 50 multiple choice questions so that you can ace your exam with confidence. We're going to move quickly, so hit the pause button if you need more time. Let's get going. 50 exam questions in 30 minutes. Good luck.
A contract created to pursue an illegal objective is void, valid, breached, voidable. The answer is void. If a contract calls for an illegal act to be performed, it cannot be enforced in court. Therefore, it is void. A contract that does not have a legal objective is voidable, voidable and unenforceable, valid but unenforceable, void. The answer is void. A void contract is not binding or enforceable by the parties. To be valid, contracts must have the essential elements of competent parties, meeting of the minds, legal objective, and consideration. If the contract is for the sale of real estate, it must also be in writing. A contractual provision making the sale of a home subject to the buyer qualifying for a particular kind of loan is called a contingency, covenant, novation, courtesy. The answer is contingency. A contingency is a provision in a contract that requires the completion of a certain act or the happening of a particular event before that contract is binding. In other words, the contract depends on something that is not certain to happen. A provision in an offer to purchase that requires the completion of a certain act before the contract is binding is known as a lis pendens, covenant, contingency, restriction. The answer is contingency. A contingency is a provision in a contract that requires the completion of a certain act or the happening of a particular event before that contract is binding. In other words, the contract depends on something that is not certain to happen, such as loan approval. A lease for less than 1 year is unenforceable. May be oral, but must be reduced to writing within 30 days. Must be in writing. May be oral. The answer is may be oral. Leases for 1 year or less may be oral. Leases for over 1 year in duration must be in writing. A promise to perform in a contract is called an option, a service contract, consideration, a contract. The answer is consideration. Consideration is money, promises, or something of value. In the purchase contract, the consideration is the promises to perform made by the seller and buyer. A prospective buyer gave a deposit to a broker and signed the usual form of an offer to purchase property. The deposit form included the statement, "This offer is for 5 days." A day later, before the offer had been accepted by the seller, the buyer contacted the broker and withdrew his offer and demanded the return of his deposit. The broker has 5 days to obtain the seller's acceptance. Should tell the buyer that the earnest money deposit will be forfeited if the buyer withdraws his offer. Must return the deposit to the buyer as demanded. Must place the deposit in a neutral escrow until the 5-day period expires. The answer is must return the deposit to the buyer as demanded. An offer is not legally binding until it becomes a contract. Therefore, the buyer may terminate an offer, regardless of how it is worded, anytime before there is communication of the seller's signed acceptance of the offer. All of the following are essential to a valid contract except a lawful object, offer and acceptance, competent parties, monetary consideration. The answer is monetary consideration. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, legal object so that the contract is legally enforceable in a court of law. All of the following are essential elements of a valid real estate contract except cash down payment, competent parties, consideration, offer and acceptance. The answer is cash down payment. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, the offer and acceptance of the offer, legal consideration, legal object, so that the contract is legally enforceable in a court of law. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, the offer and acceptance of the offer, legal consideration, legal object, so that the contract is legally enforceable in a court of law. A voidable contract is invalid, and the contract cannot be enforced by either party. Illegal because all of the elements to create the contract are not present. Void because one party to the contract has an unfair advantage over the other party. Enforceable, but is subject to rescission by one of the parties to the contract. The answer is enforceable, but is subject to rescission by one of the parties to the contract. A voidable contract is enforceable. It has all of the necessary elements of a contract. A second offer made on a property prior to the seller's acceptance of the first offer should be submitted to the seller immediately, rejected by the broker, returned to the offer if it does not provide better terms than the first offer, held pending a decision on the first offer. The answer is submitted to the seller immediately. It is the broker's obligation to submit every written offer to the seller promptly until an offer is accepted, regardless of the terms of the offers. The broker must present all offers up to closing. However, once the seller has a binding executory contract, these offers may only become backups to the contract. Consideration in a contract may be an exchange of promises. All of these is earnest money, is not essential. The answer is may be an exchange of promises. Consideration is essential to a contract. It may be an exchange of promises, a promise for an act, money, etc. If a contract is signed under duress or undue influence, the resulting contract is valid, valid but unethical, void, voidable. The answer is voidable. Contracts signed under duress or undue influence are voidable by the injured person, who has the option to rescind or accept. Certain contracts are required to be in writing because of the statute of frauds, statute of limitations, statute of contracts, statute of wills. The answer is statute of frauds. The statute of frauds specifies the types of documents and contracts that must be written in order to be legally enforceable. Forcing someone to do something against his or her will in the execution of a contract is called duress, menace, undue influence, stress. The answer is duress. Duress is forcing someone to do something. Undue influence is taking advantage of someone. Menace is a stronger form of duress, where the person feels in danger. Coercion and duress of a buyer would make a contract voidable at the option of the buyer, voidable at the option of the seller, invalid, voidable at the option of either the buyer or seller. The answer is voidable at the option of the buyer. If, in arriving at a contract, a person is taken advantage of, the contract is voidable by that person. As a result, he or she is given the choice of allowing the contract to stand or of going to court and having the court declare it void. The other party to the contract does not have this choice. Therefore, the contract is not void. Every valid contract must meet all of the following requirements, except An offer and acceptance mutually agreed upon. Earnest money. Legally competent parties to the contract. A legitimate purpose. The answer is earnest money. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, promises, something of value, an act, giving up the right to act, etc., and legal object so that the contract is legally enforceable in a court of law. Earnest money and not consideration and is not required. In a home sale, the seller promises to sell and the buyer promises to buy. This is known as quid pro quo, consideration, mutual agreement, offer and acceptance. The answer is consideration. Consideration is money, promises, or something of value. In the purchase contract, the consideration is the promises made by the seller and buyer. In reaching an agreement through the process of offer and acceptance, the seller can be neither the offerer nor offeree, either the offerer or offeree, the offerer only, the offeree only. The answer is either the offerer or offeree. If the seller counters the offer, he or she becomes the offerer. If a seller accepted an offer but changed the date of possession and initialed that change, it would become a counteroffer subject to acceptance by the buyer. None of these. The buyer would be bound by the contract and unable to withdraw his offer. The offer would become a counteroffer, and if the buyer did not accept, he would lose his deposit. The answer is it would become a counteroffer, subject to acceptance by the buyer. The change is a counteroffer and becomes binding only if accepted by the buyer. If the buyer does not like the change, he need not accept it and can get his deposit back. If a minor signs a contract to buy real estate, the resulting contract is void, valid but unenforceable, valid, voidable. The answer is voidable. Adults may not allow minors to enter into real estate contracts. If they do, the contract becomes voidable by the minor, not the adult seller. In a real estate contract, the consideration given by the buyer is a promise to the property being sold, buy the property, mutual agreement, the earnest money. The answer is buy the property. Consideration is money, promises, or something of value. In the purchase contract, the consideration is the promises made by the seller and buyer. In the case of a mutual mistake in material fact resulting in no mutual agreement, the contract is valid but can be rescinded, voidable, void, unenforceable. The answer is void. If there is a mutual mistake, there is no meeting of the mind, so the contract is missing an essential element and is void. Once an offer is made, it can be withdrawn at any time until acceptance is communicated, until it is accepted only by the offeree. The answer is until acceptance is communicated. Only the person who made the offer can withdraw it and has the right to withdraw, even if accepted, as long as the acceptance has not been communicated. An offer can't be withdrawn after acceptance is communicated, since it has become an executory contract at that time. One of the requirements for a valid contract known as mutual agreement is also called a dual agency, bilateral contract, meeting of the minds, mutual rescission. The answer is a meeting of the minds. Mutual agreement or meeting of the minds is when both parties reach an agreement with all the terms of the offer and accept them. This acceptance allows the offer to become an executory contract. Most contracts are bilateral, which means both parties agree to perform. Dual agency is representing both parties to a contract. Rescission means terminating a contract. Offer and acceptance are required in order to have no fraud, mutual agreements, consideration, legal objective. The answer is mutual agreement. Mutual agreement or meeting of the minds is when both parties reach an agreement with all the terms of the offer and accept them. This acceptance allows the offer to become an executory contract. Taking advantage of someone in the execution of a contract is called undue influence, menace, duress, stress. The answer is undue influence. Duress is forcing someone to do something. Undue influence is taking advantage of someone. Menace is a stronger form of duress, where the person feels in danger. The absence of which of the following would render an earnest money contract unenforceable? Earnest money deposit. Legal purpose. Legal description of the property without the street address. Time period for seller's acceptance. The answer is legal purpose. An earnest money contract must contain the elements necessary for a real estate contract: legal object, competent parties, offer and acceptance, consideration, and writing. There is no requirement for a legal description, an earnest money deposit, or a time period for acceptance. The deposit is used only to show good faith on the part of the buyer. Without time period for acceptance, the offer is valid for a reasonable time, as determined by the courts if necessary. The party who makes an offer is called the offerer, seller, buyer, offeree. The answer is offerer. ORs give, so the offerer makes the offer. EEs receive, so the offeree receives the offer. The buyer or seller can be either the offerer or offeree if the offer has been countered. The current tenant has 3 months left on her lease. She has just been offered an out-of-state job offer. The landlord agrees, upon finding a new tenant, to release the current tenant from her lease and sign a new lease with the new tenant. This process is known as assignment, novation, reservation, satisfaction. The answer is novation. Novation is releasing a party from a current contract by writing a new contract. An assignment allows the party to assign rights but does not remove liability to perform. The general rule is that a buyer may not withdraw his offer after an earnest money deposit has been given, after proper notification of the seller's acceptance of the offer, after the seller's acceptance of the offer but before the buyer is notified, before it is presented to the seller. The answer is after proper notification of the seller's acceptance of the offer. An offer is not legally binding until it becomes a contract. Therefore, the buyer may terminate an offer, regardless of how it's worded, anytime before there is communication of the seller's signed acceptance of the offer, which then becomes an executory contract. The buyer, even though he has signed the purchase and sale contract, can withdraw his offer to purchase until the acceptance is mailed, signed by the selling broker, delivered to the offerer's residence or place of business, communicated. The answer is communicated. The acceptance must be communicated to create a contract. This can be by mail, delivery, fax, etc. Communication may be effective when sent rather than when it is actually received. The party to whom an offer is made is called the seller, buyer, offerer, offeree. The answer is the offeree. Ors give, so the offerer makes the offer. E's receive, so the offeree receives the offer. The buyer or seller can be either the offerer or offeree if the offer has been countered. The last requirement in the process of offer and acceptance that creates the executory contract is acceptance. The offerer's signature, communication of acceptance. Counteroffer. The answer is communication of acceptance. Once acceptance is communicated to the offeree, an executory contract is formed. Acceptance without communication does not create a contract. All parties must sign the offer to create a valid contract. To be legally enforceable, an option or a contract for the sale of real property must be all of the following except in writing, supported by consideration, initialed by a real estate broker or attorney, signed by all parties. The answer is initialed by a real estate broker or attorney. All contracts must have consideration, and real estate contracts must also be written and signed. There is no requirement for a broker or attorney to be involved. Note that the general rule for written contracts is that all parties must sign. However, there are exceptions in practice. Two men entered into a real estate contract. After some time had elapsed, they decided to change the contract, and a new contract was executed to replace the original. This is an example of novation, accession, rescission, subrogation. The answer is novation. Novation is the substitution of a new obligation for an old one, or substitution of new parties to an existing obligation. For example, if a buyer assumes a seller's loan, and the lender agrees to release the seller from liability for the loan, this results in a substitution of new parties to an existing obligation and would be a novation. Using threats to force a person to enter into a contract involuntarily is known as negligence, duress, risk, fraud. The answer is duress. Duress is the use of threats to force a person to enter into a contract. It would cause the contract to be voidable. The requirement that a contract not be for an illegal purpose or against public policy is referred to as specific performance. The common law, meeting of the minds, legality of object. The answer is legality of object. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, and legal object so that the contract is legally enforceable in a court of law. What is the meaning of novation? Estoppel, ratification, rescission, substitution of a new contract between the same or different parties. The answer is substitution of a new contract between the same or different parties. Novation is the substitution of a new obligation for an old one, or substitution of new parties to an existing obligation. For example, if a buyer assumes the seller's loan, and the lender agrees to release the seller from liability for the loan, this results in a substitution of new parties to an existing obligation and would be a novation. To be enforceable, a real estate sales contract must, in all cases, have an earnest money deposit, competent parties, the signature of a wife of a married seller, a witnessing by a disinterested party. The answer is competent parties. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, legal object so that the contract is legally enforceable in a court of law. Earnest money and witnessing are not required. The signature of a spouse is required only if the spouse is also an owner. If the property is owned in severalty, the other spouse need not sign the contract. Where no time period for acceptance by the offeree is stipulated in an offer, the offer will lapse in 24 hours. Lapse after a reasonable time. Not lapse, it must be revoked by the offerer. Lapse in 48 hours. The answer is lapse after a reasonable time. If a time period is not stipulated, a reasonable time is allowed. When a counteroffer is made, the original offer is amended, conditionally accepted, partially accepted, terminated. The answer is terminated. Any change in an offer terminates the offer and creates a counteroffer. Which of the following is the best description of a contract? An executed document in which all essential elements have been fulfilled. An agreement between competent parties based upon legal consideration creates legally enforceable duties and obligations. A contract whereby all parties to the contract have contractual ability. A contract between competent parties, giving each the right to cancel the contract, provided legal notice is given. The answer is an agreement between competent parties based upon legal consideration that creates legally enforceable duties and obligations. To have valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, and legal object so that the contract is legally enforceable in a court of law. When an offeree rejects an offer and becomes an offerer, the immediate result is a counteroffer, executed contract, valid contract, executory contract. The answer is a counteroffer. Rejecting an offer and creating a new one creates a counteroffer. The parties also change places. The offerer is the party who created the new offer, and the offeree is now the buyer. When the parties to a contract have fully performed the terms, the contract may properly be described as executory, acknowledged, expressed, executed. The answer is executed. If a contract is one in which one or both of the parties have not yet performed, it is called executory. If the contract is one in which there is nothing left to be done by either party, as it has been completely performed by both parties, it is considered to be an executed contract. A buyer has purchased a property that, according to the seller and the contract, will allow business use. The buyer later discovers, prior to closing, that business use is not allowed. In this case, the contract can be terminated only by the seller, is void since it now lacks a lawful objective, has not changed, and the buyer must close or be sued, is voidable by the seller. The answer is void, since it now lacks a lawful objective. The stated purpose of the contract is to buy a business, which the buyer does not have the right to operate, so the contract lacks lawful objective and is void. A buyer agreed to buy a property for $145,000, signed a purchase and sale contract, and deposited $5,000 earnest money with ABC Realty. The seller was unable to provide marketable title. In this case, the next step is for ABC Realty to return the entire amount to the buyer, forward the entire amount to the seller, return the earnest money to the buyer after deducting the commission, divide the earnest money in half between the seller and buyer. The answer is to return the entire amount to the buyer. If the seller cannot deliver title, the buyer is entitled to the return of his or her earnest money. A contract of sale accepted by the seller with the stated understanding that the seller has an executory contract is legal but unethical, illegal, a backup contract, a lease with an option. The answer is a backup contract. The seller may legally accept a backup contract if he or she has an executory contract. A seller sold his house under a contract of sale, which called for settlement within 30 days. The seller later decided that the sales price was too low and refused to close on the sale. All of the following are options the buyer might choose except suing for monetary damages, suing for specific performance, rescinding the contract, liquidated damages. The answer is liquidated damages. The buyer does not have liquidated damages as an option, since he has no earnest money or other funds from the seller.
You made it to the end. Congrats! If you're looking to study more right now, head over to our exam practice question playlist. We have hundreds of questions waiting for you. Subscribe to our channel and you'll get notified when we release our next exam prep tools to help you pass the real estate exam. Good luck. See you soon.